Mr. Chair, I'd like to make a motion to approve the May invoices.
Motion by Mr. Shirley,
Second.
second by Ms. Mizell. All those in favor? Motion approved. Second on the agenda is the approval of the May 14th, 2015 minutes. And for the record, Ms. Holland is going to be late. So approval of the May 14th minutes. We do have a thing on the last page where we went into a closed session. We came out of that closed session, the recorder was off. So we need to know who made the motion and who seconded the motion. Does anybody remember? Do you remember? Come on,
I'll
you got the
refer to
best one.
council.
You got the best one. Not on the, when we come out of closed
Okay,
session.
come out of closed session.
Last month. The recorder was off, so
Maybe Janet.
I think Janet did. I think Janet did make the motion.
Yeah, I believe Janet was.
And I think you made the second.
Yeah.
So we'll fill in, Ms. Holland made the motion and Ms. Mizell made the second. Any other changes on the minutes? So we'll need approval, motion to approve.
I make motion to approve the minutes.
Motion by Ms. Mizell,
I'll second.
second by Mr. Solsky. All those in favor?
Aye.
Motion approved. Next thing on the agenda is approval of the June agenda. Need a motion to approve the agenda.
Any changes?
No, anything is enough? No.
Mr. Chairman, I move we approve the June agenda.
Motion by Mr. Smith,
Second.
second by Mr. Caldwell. All those in favor?
Aye.
Motion approved. All items for postponement, withdrawal, there are none, is there, Matt? And then the consent agenda, we have two eligible. Is there anybody here to speak on the Everly property other than the applicant?
Depends on what.
So you want to hear it?
Do what?
So you want to hear the Everly property, you want to hear that one?
Yeah.
Okay, so that one will be heard. And then the Sonic Drive-In addition. Is anybody other than the applicant here to speak against the Sonic Drive-In application? So the Sonic could go consent. So we'll need a motion to approve that, please.
I'd like to make a motion to approve the application PDP 2015-13 by Sonic Drive-In.
Motion by Mr. Shirley,
I'll second.
second by Mr. Solsky. All those in favor?
Aye.
Motion approved. All right, Sonic Drive-In, you just come up and sign the papers, please. All right, the first order of business tonight will be the Winding Oaks Cluster Subdivision. Megan, you have that?
I can give you a summary if you want. Tonight, it's, if you can pull that up. The question for you is not the actual application, review of the application, but it's.
If I could, I've got a bit of a summary, and I've given copies to the two attorneys, so if I could just, at least I would like to think I could knock that out in a second. No, that's yours, this one's mine. Thank you. You all will recall, Winding Oaks zone change was heard, I think, December and February. And in February, the commission voted 5-4 to recommend denial to the fiscal court. The application, the packet, the record, and all was sent up to the fiscal court. It was never heard by them. It was scheduled, 2 or 3 different times. It never actually got heard, and it was then withdrawn by the applicant. And that withdrawal was prior to the 90-day deadline in which the fiscal court had to take action of some sort. Had the application remained before the fiscal court for the full 90 days without fiscal court action, then by operation of law, the commission's recommended denial would have become the law of that application. Now, or had the application been denied, obviously, then it would have been a rejected application. The reason that is of some importance is because when it was withdrawn, the applicant filed a new application for that property. And there is a provision of our zoning ordinance in Article 6 on page 123, I believe, that says the Planning Commission may refuse to review a proposed map amendment which has been proposed and rejected within the last year. So the question is raised whether it was rejected because it wasn't acted upon within the 90 days, or whether being withdrawn, then it wasn't rejected. When the new application was filed, Joe placed the new one on the agenda, believing it had not been rejected because it had been withdrawn. He talked to me about it. I concurred with him. Mr. Simpson expressed his displeasure and disagreement with that position, and in fact has asked for that interpretation to be reviewed. Our ordinance provides for interpretations by staff and all to be reviewed. It goes to the Board of Adjustment. On the, 2nd, I believe, of July, it is to be considered by the Board of Adjustment whether that comprised a rejection of the application, or by being withdrawn, does that mean it wasn't rejected? Now, let me see where I am on this. July 2nd is when the Board of Adjustment will take this up. It is currently scheduled, the application itself, to come before this body on July 9th. Now, if the Board of Adjustment finds it was rejected, then this board has a discretion to decide not to hear it again for up to 1 year. If they find it was not rejected by virtue of being withdrawn, then it's on the agenda and it's scheduled for a hearing before you on July 9. The reason this is even on tonight is I believe it would be helpful to everybody who's concerned with this application to know whether or not you're going to hear it. Now, if the board comes back on the 2nd of July and says it is rejected, then you'll have the discretion to say then we're not going to hear it for a year, or we're going to hear it, whichever direction you take. And of course, if the board says it wasn't rejected, it's going to be on anyway. But if you could make that determination tonight, discuss that and make whatever determination you will, then everybody knows what it is to prepare for, if anything, for July 9th. Now, obviously we have Mr. Simpson and Mr. Langford here representing persons with specific interest in the application. They may wish to say something else to this, but that's why this is on the agenda tonight, and the only reason it's on the agenda tonight.
So do we have to hear testimony from anybody else, Charlie? Or?
No, it's not for any testimony. It's not a public hearing. This is
Okay.
just simply to decide whether you're going to hear it or not. And as I said, Bruce Simpson probably has something that he would like to add. Bruce Langford probably has something to add. But otherwise, no, it is not a public hearing. I mean, you don't have to listen to any of us, for that matter. But I thought you might want to hear at least the two attorneys.
I guess before we go any further, Charlie, can you swear everybody in, please?
Oh, I'm sorry. If we could, the two attorneys, but anybody that signed in to speak tonight, if you could all just stand and raise your right hand, and we'll just get everybody sworn at once. Oh, there's got to be more than that. Oh, this is good news. Do you all swear or affirm the statement you're to make tonight to be the truth to the best of your information and belief? Thank you.
All right, I guess where I'm at with this, and I hope everybody's understanding what Charlie's saying, we need to make the determination whether we denied it or whether we want to hear it again. If we didn't deny it, we need to go ahead and decide whether we want to hear the application.
Not if you denied it, because you didn't deny it, you recommended its denial. But once it went up, since it wasn't heard and decided otherwise within the 90 days, as Mr. Simpson is probably going to argue, that amounts to a denial, and therefore it was a rejected application. Or because it was withdrawn, it really wasn't acted on, and it wasn't there the 90 days because it was withdrawn, and therefore it's just an active application. But anyway, don't let me steal any more thunder, please.
Go right ahead.
So everybody's knows where we're at. Okay, since Mr. Simpson's already up here, I guess we'll hear Mr. Simpson first.
Thank you, Mr. Chairman. My name is Bruce Simpson. I'm here tonight on behalf of Kim Jedlicki. I represented Ms. Jedlicki before the February hearing in which you all denied the applicant's zone change request. As Charlie pointed out, after you all denied the recommendation, denied the rezoning, it went to fiscal court. The fiscal court never took a final action on it, and the applicant withdrew the application. So that in terms of any governmental entity taking any kind of action, final action, on the applicant's zone change request, it was this body, which the record is beyond dispute, you rejected the application. Now, the applicant had the opportunity to go to the fiscal court and overturn that rejection, but he chose not to do so. Subsequently, on May the 1st, applicant filed another application. It's the same applicant, same property, the same property owner, and the same rezoning request, although it is positioned a little bit differently. We found out about this new application on, I believe it was May the 13th, and Joe Kane called me and said that he had made an interpretation of the zoning ordinance to the effect that the Planning Commission, it was not within their purview, your purview, to hold the applicant up potentially 1 year because there had been no rejection of the zone change, despite the fact that you all had rejected it, and despite the fact they could have taken an appeal, and despite the fact that they withdrew their appeal to the fiscal court, and the only official action was rejection. But it was Mr. Kane's interpretation on his own that you all had no right to impose a 1-year delay on a refiling on the same property by the same applicant for the same rezoning. We took an appeal of that decision, Mr. Kane's decision, to the Board of Adjustment, because by law, as Charlie pointed out, that's what we're required to do. Now, our appeal really is twofold. Number one, Mr. Kane didn't have the authority to usurp the decision-making ability of this government, of this Planning Commission. Didn't have the authority to usurp your position in making that decision. That was your decision to make. And it should have been your decision to make, but he took it upon himself to make it for you, and now that decision's in the Board of Adjustment. And so what we've got now, we've got two different forums, the Planning Commission and the Board of Adjustment, that are involved in making a decision about this case, and which is only increases the potential for unnecessary appeals to the circuit court that becomes necessary. My recommendation at the first threshold is to not make any decision about rehearing the applicant's rezoning request again tonight, but let the Board of Adjustment make its decision first so that it's completely not tainted by anything you all do, whether it's to vote to rehear the case or vote to not rehear the case, depending on what the Board of Adjustment decides. Let the Board of Adjustment make a decision, and then we could come back and argue if it is within your purview, which I believe it clearly is, to decide whether you want to hear the case. I don't think we ought to keep creating more confusion and more hearings before different decision-making tribunals. So my first request is, in terms of responding to the matter that's on the agenda tonight, is that your decision has already been made by your staff. Joe Kane has determined you can't make a decision on Mr. Welch's application because it was never rejected. It should have been your decision, but you didn't have the opportunity to make it because he made it for you. That's now before the Board of Adjustment on appeal among that issue and other issues, which is regrettable, but it's there. We're going to be heard on July the 2nd. So I'm trying to minimize the potential for appeal, minimize the potential for confusion, and simply say that you're better off, in my judgment, not to make any decision tonight. Let the Board of Adjustment hear the case on July 2nd, and then we come back before this body, should that be necessary. Now, in the event that you don't follow my recommendation of taking no action on this case tonight, the applicant wants to have another shot at the rezoning. And so what you're doing is hypothetically deciding that if the Board of Adjustment were to determine that you do have the right to impose a one-year moratorium, you're making that decision tonight, hypothetically, based on what the Board of Adjustment determines on July the 2nd. So let me share the reasons why you shouldn't hear this applicant's case again. Again, we're talking about exactly the same property, exactly the same acreage, exactly the same property owner, exactly the same applicant, and exactly the same rezoning. Some differences in how they've shifted it around. But I'm privileged to represent applicants for land use cases and also people who have issues with a given application. Let me share with you how it works when you're representing an applicant, such as in this case. You get together with your client. He says, what do you think we are up against? Well, what kind of issues are on the property? What might people object to if there's going to be objection? I'm looking across the street. I see landslide subdivision. I see horse farms contiguous and close by. High potential for people to oppose you. So what do we need to do our homework in advance? And we're talking 2 or 3 months before we even come to you for a hearing. The applicant controls the flow of when it comes to you. And it's usually 2 or 3 months of work in looking at what are the potential hot spots. What do we got to be prepared to deal with? So that when we have this hearing, we're ready. We're prepared to answer all the questions and issues that might come up. And then, of course, you find out, it's no secret, if you have opposition, which they found out prior to December, people are upset. What were they upset about? What were the foreseeable issues that had to be addressed in terms of homework at the December hearing? Obviously, many sinkholes on the property. That's not in dispute. Ironworks Road, access, narrow road, dangerous road, number of accidents, obviously. Stormwater runoff.
Can I ask you one question?
Yes.
Does this have anything, I mean, we've heard all the water runoff, all the dangers, and
Exactly.
we would just like to try to keep it down to whether we should hear this application.
And my
Whether-
point is, Mr. Chairman, you've heard this twice,
Okay.
all of this. And now they want to come back for the third time in 8 months and hear it all over again. The same issues that have already been discussed, experts retained in December. They were prepared to deal with it, or should have been in December. 2 or 3, 4 hour hearing. You said we got to have more information.
I mean,
Come back in February.
What I'm thinking is that we're not going to try to base that decision we're basing tonight on whether it's a bad development or such. We need to
That's
base
not my
our
point.
decision.
My point is, you have the right to say, we have heard these same arguments in December and in February, and now they want to come back in July. The people have to come out every single time. And so the question then, if you're going to decide what you're going to do, if you're not going to wait, which you should do until the Board of Adjustment makes a decision, but if you're going to vote tonight to give the guy another shot, if the Board of Adjustment allows you to do that, why should you do it? You shouldn't. You've already heard all this twice before. People got to take time off from work 3 times in 8 months, and we're going to hear the same issues argued again. Nothing has changed. Slight reconfiguration, but the same issues all over again. In my judgment, they had the opportunity to answer the questions the first time and didn't, second time and didn't. And I think, from the standpoint of the benefit of the public, to say, you know what, you're right. Come back in a year, and we'll hear your application. That's fair. You want to come back again, that's fine. But to keep coming back time after time, 3 times in 8 months, I think is unreasonable. I think it sends a bad message to the public that your decision is not respected, that they've got to come down here and argue the same thing all over again after you've already heard it. 3 times in 8 months is an unreasonable burden on the public to have to respond to the same case. So 2 things. Number one, the best recommendation for you, in my judgment, to avoid clouding up this case with additional potential appeals is to not do anything until the Board of Adjustment makes its decision on July the 2nd, 3 weeks away, and then come back, if they, depending on what they rule, the next month in August, and should we hear this case. But I have to make both arguments now because you're going to make a decision tonight. So, number one, let the Board of Adjustment decide. Take no action tonight. If you do take an action, then I think you need to respect the public's right not to be inconvenienced. Come down here in July and argue the same thing you've heard 3 times already in 8 months. Thank you.
Thank you.
I have any questions, I'll be happy to respond.
Does anyone have any questions for Mr. Simpson? Thank you, Mr. Simpson. Mr. Langford?
Mr. Chairman and members of the Planning Commission, my name is Bruce Langford. I think everything he said is something he should say at the Board of Adjustments meeting. I don't think that's something that you should concern yourself with this evening. Mr. Perkins has made a good presentation. Charlie, I agree with everything you have here. I think number 11 is what I would ask that you do. Make a decision this evening whether or not, if this application is rejected, you will still hear it if the board makes that determination. If it's not rejected, you can still hear it. I don't think it's the same thing. Parties are the same, the property is the same, the application the same for zoning, but the plan is different. And the plan is different because we filed a new application. With all due respects, I want to correct Mr. Simpson on a couple of things. He first started out saying you denied the application, which you did not. He later switched over to say that you rejected the application, which you did not. I would like to correct the record to say that, in my opinion, what you did was recommend denial. And there's a big difference between recommending, rejecting, and denying. I don't have to say any more about that. With respect to what you might hear at the new hearing, I'm going to limit that as much as I can. Mr. Jones, I'm not going to bring you a lot of stuff you've already heard. It hadn't been, 3 months? I'm not going to put you through that. I'm going to put enough into the record so that you'll know what our application is all about, and that the fiscal court will have enough time and enough information to make a determination on this application. So I don't agree that this application is the same. It's, quite frankly, quite different. So with all due respects to Mr. Simpson and his fine people, on behalf of Mr. Welch, I ask that you go along with your attorney's suggestion and recommendation, and that is that you make a decision this evening whether, if the application is rejected or determined to have been rejected by the Board of Adjustments, that you still let us be heard. If they determine it was not rejected, then as I understand what Charlie is saying, we have a right to be heard. I don't want to give you any more information, Mr. Jones, to the people on the Planning Commission that you actually need. I'll entertain any questions. But we do very much want to know this evening, can we be heard at the July meeting? We need to plan accordingly. Be happy to respond to anybody's questions.
Does anyone have any questions for Mr. Langford?
Do you know what the date was that this first application was withdrawn?
When it was withdrawn?
Yes.
We withdrew it before the 90 days is up. We withdrew it before the 1st of June, so they would get on the June date. I don't know if I have it here. I have it in my file.
Excuse me, wasn't that before the 1st of May?
That's right, before the first.
Yeah, before the first, I don't know the date, but I think it would have been before the 1st of May, so you could be on, or
Right.
could have been
I
on
have it in my
tonight's
file, but I don't
agenda.
have it here now. But it was within the 90-day period.
Is there any other questions from Mr. Langford?
Thank you, Mr. Jones.
Thank you.
Members of the planning commission.
Mr. Chairman, a question of our attorney, Mr. Perkins. Did I understand you to say that no matter what the Board of Adjustments does, we can go either way?
Well, I don't want it to sound like, we're just disregarding, much less disrespecting the Board of Adjustment. The issue before them is, was the application rejected? Because if it was rejected, you have the discretion to say, we're going to put you off up to 1 year. If they say it's not rejected, then it's just an application that you hear in the normal course. So it's not that it doesn't matter, it's an important question, but you have the discretion, if it was rejected, to hear it anyway. And if it was not rejected, then again, you hear it in the normal course anyway. So again, risking sounding like we're disrespecting what they're going to do, it is an important question. In fact, we've never had the question come up in the 30, goodness knows how many years I've been hanging around here.
Charlie, I guess my next question is, we do have some people signed up to speak on this. Are we required to let those speak?
No, this is not a public hearing. And the only reason we heard the two principal speakers is because they do represent some, and they are trained in it. But this is not a public hearing, so there is no requirement that you hear public comment. This was just done simply as a courtesy to both sides and to give you any additional information, but there is no public hearing tonight.
And I mean no disrespect to anybody, but if everybody has enough, if everybody's heard enough testimony and is ready to make a decision on this, then I think that's which way we need to go. If not, we'll let some of the other folks speak if you want to hear them speak. But I'll let the board decide what they want to do.
Mr. Chairman, I would say that, in agreement with Charlie, that I don't think that this commission is going to reject any application. We only recommend acceptance or denial. You recommended denial based on 2 or 3 things in particular: the entrance on Ironworks and site distance, I think the biggest issue is that none of these things even matter at this point. What I want to say is I don't think that we rejected it. It would have been rejected if the fiscal court had voted to reject it, which was our recommendation. So as far as I'm concerned, if it was withdrawn before the 90 days was up, it has not been rejected. And I think we should hear it again.
So is that a motion to
Do we need a motion, or
Put
do we
the,
just need a
Yes.
ruling?
No, well, I prefer, yes, a motion second, and then, of course, any discussion on the motion, but then, yes, a vote on the motion.
So your motion's, Mr. Smith?
I would move that we consider this new, Winding Oaks cluster was not rejected. It was-
Excuse me, but can I make a suggestion? The determination as to whether it was rejected will be made by the Board of Adjustment, because that's the interpretation. So if I might suggest, Mr. Smith, that the motion would be, if the board determines that it was rejected, then you move that we do not defer it up to a year, but to go ahead and hear it. I believe that would be consistent with what you're saying, but yet leave that decision as far as rejection goes to the Board of Adjustment.
So I need to make the motion that we would be willing
That
to hear
that
this.
if the board finds it was rejected, that we not defer it up to a year, but go ahead and hear the new application.
So moved.
So everybody get that motion? So we need a second.
I second.
I'll have a second by Ms. Melville. So what we'll do a roll call. I'm just gonna call out names random instead of starting on one end or the other like we always do. I'll just start out with names, okay? Mr. Moran?
Let's hear it, let's bring it back.
Yes. Yes would be to bring it back.
Yes, yeah, a yes
At
vote
the,
would be,
at the
yes,
July
that's
meeting.
correct.
That would be deferred, yeah.
Mr. Caldwell?
Yes.
Mr. Smith?
Yes.
Mr. Shirley?
Yes.
Mr. Wiseman?
No.
Ms. Mizell?
Yes.
Mr. Solsky?
Yes.
6 yeses and 1 no, so we have a motion to bring it back, and it's approved to let them bring it back on the July agenda, pending the Board of Adjustment ruling. Okay?
Very good.
Good. Thank you, guys. All right, next on the agenda, we'll let the room clear, please.
Just for everybody's information, that, our next meeting is July 9, correct? And is that right?
I have to look at my phone.
And this would be the actual, there will be a hearing that night then on the application.
Yes.
July
Okay.
9th.
Just want to make sure everybody knew that before we get out of here.
Next up on the agenda is the Cox-Smith zone change. And I'm going to recuse myself from this, and Mr. Shirley will take over on this meeting.
Oh.
Okay, Megan, have you got this one? This is the application ZMA-2015-04, the Cox-Smith zone change.
Yes. This is a zone change request for an approximately 2-acre portion of a parcel located on the southwest of the intersection of Cynthiana Road, US 62, and Delaplane Road. It's located across the street from the Lanes Run Business Park on Cynthiana. The request is to change the zone from the existing R1A and A1 zones on the property to B1, which is a neighborhood commercial zoning district.
Excuse me, Megan, since the chair's not, if you could note on the record, Janet's now here.
For the record, note, Miss Janet's here.
Excuse me, I'm sorry.
The site proposes, in addition to the zone change request, an applicant has to bring in a concept plan. And on that concept plan, they're proposing access through the existing entrance on Delaplane Road, as well as a proposed entrance from 62 on that lot. There you go. On the screen, this is an aerial showing the existing zoning for the property as well as surrounding properties. This is the parcel in question. The applicant also owns a lot just north that is currently zoned B1, and the concept plan that has been submitted incorporates both lots. So we're considering the zoning for the southern portion, but the concept plan for both lots. You can see the business park just west of the property. It's BP1. There's the existing B1 on the adjoining property, also owned by the applicant, as well as a little bit of leftover zoning in the business park. The majority of zoning in the surrounding area is agricultural, and that's in the area outside of the city limits in the urban service boundary. So in the city, we've got our more intense uses, and the county, our agricultural uses. Maybe. I just included a couple photos of the site. This is from Delaplane looking west, I guess you would say. This is the concept plan submitted along with the application. It's probably going to be a little bit difficult to see, but the zoning, this little bit in this area that I'm showing is the R-1A, which kind of appears to be some leftover zoning from past zone changes, and it basically is along the right-of-way and the road frontage. It's not really usable in the amount of space that's provided in that zone district, so you wouldn't be able to do a traditional R1 development there. This portion of the property on the southern, about the southern half, a little bit more, is in the A1 zone. And then the northeast corner has existing B1, and then the majority or the entirety of the second parcel is B1. But you can also see the city of Georgetown city limits, as well as the urban service boundary, cut approximately where I'm showing on the screen. So they're kind of half in, half out in terms of where they fall. I can come back to the concept plan, I guess, a little bit later, but I'll just describe it in general, but then we can really go into the zone change request itself. This is the proposed access for 62 and proposed access from Delaplane Road. Originally, this was shown with the buildings kind of on the back and parking in the front. From talking with the applicant, we were trying to get slightly more of a neighborhood-oriented or a village type approach. And so they've broken the development down on the concept plan into several smaller buildings, but they're proposing with this site or in that concept plan 17,550 square feet of building space on the two lots, which is about 11% coverage on the site. In the B1 zone, you're allowed up to 75% coverage. So the scale of what they're proposing is far under what could be allowed, but typically the B1 is on smaller lots, so that level of development is a little bit different. Along with that 17,000 plus square feet would be 117 proposed parking spaces. I've included a little bit of information about the B1 zone district, just for everyone to see. The neighborhood commercial, and I'm going to read this because I feel like it's an important part of your decision, is it says that the district is to be used for retail trade and personal services enterprises, which will meet the regular needs of the occupants of the surrounding residential areas. And it's basically saying, if you look in the permitted uses, it's meant to be for the neighborhood consumption, and the applicant's going to argue that the neighborhood in this case should be considered more than the residential uses, that it should be considered the business park, the Lanes Run business park. But the way that it's written, it's really meant for a neighborhood. And I think what they're proposing does not really fall into a B1 standard. I think that it really serves more of a B2 with its location and the intensity of use that they're proposing. The setbacks that are required on a B1 property are 25 feet for the main and accessory structures in the front of the property. Side setbacks are 0 feet and then 5 feet for accessory structures. Rear is 20 feet for the main and then 5 feet for accessory structures. With the concept plan, they've shown a development that meets those standards. There's also a landscape buffer requirement that is required between commercial districts such as the B1 district and adjoining agricultural lots. It requires a 15-foot wide landscape buffer with trees to separate the different land uses. The maximum building height is 75 feet or up to 6 stories. That would be atypical for what we have, especially in that area, but that's what our regs say. There's also max ground coverage, which I mentioned before, of 75%. In terms of the decision that you make tonight, there are several requirements from KRS, the Kentucky Revised Statutes, that regulate when the findings necessary to approve a zone change request. So section 100.213 requires that before any map amendment is granted, the Planning Commission must find that the map amendment is in agreement with the adopted comprehensive plan, or in the absence of such a finding, that one or more of the following apply, and such finding shall be recorded in the minutes and records of the Planning Commission or the legislative body or fiscal court. So if you don't find that it complies with the comp plan, you have to find that either A or B, and I'll read those because they're small, that the existing zoning classification given to the property is inappropriate, and that the proposed zoning classification is appropriate, or that there have been major changes of an economic, physical, or social nature within the area involved which were not anticipated in the adopted comprehensive plan, and which have substantially altered the basic character of such area. So I'm going to go through my interpretation of each of those three components of what the KRS requirements are. It didn't go. There we go. So the first part is, does it comply with our comp plan? In my opinion, it does not comply. The requested zone change does not comply with our comprehensive plan or our future land use map. From our 2006 comprehensive plan, in the East Georgetown area, the concept is described as respect the USB at the Lanes Run Basin watershed line. I'm going to skip a little bit, but further expansion eastward or north of current limits is not necessary at this time. A greenbelt of similar characteristics to the one created with the development of the southeast and southwest areas of the USB should be created with the development of the Lanes Run Basin. In addition, just to kind of reflect on the comments that the applicant made at our workshop meeting, he was talking about how the northeast business area calls for step down of uses. When you look at the text compared to the special planning areas for further studies, the North Georgetown Employment Center basically includes Toyota, the Lanes Run Business Park, and the business park up north of Del Plain and Cherry Blossom. It goes right next to, but it stops at US 62 Cynthiana Road. So this parcel is just on the outside, but in general, the comp plan is talking about the step down of uses. But in my opinion, the existing zoning and the future land use map already lay out that proposal for how the step down should work. So you have the higher intensity uses of Toyota, the manufacturing plant, to a less intense use of the business park than towards our agricultural communities. And so I think that looking at what our comp plan was calling for, it's really not, it does not recommend expanding our USB or our city limits in that area at this time. That's directly from the text. And it would also, by granting this request, it could potentially increase that area when we are concerned about keeping infill and development within our existing limits before we expand. I have a map here of the North Georgetown Employment Center and areas for small areas plans. I can pass that around if that's useful.
Sure, thank you.
So the B1 use also doesn't comply with the future land use map, which is a component of the comp plan. So we use the comp plan, our actual text, maps, documents in there. The future land use plan is one of the things that's adopted at the same time as the comp plan, and it specifically acknowledges and recognizes the Lanes Run Business Park and calls for the future existing and future land use to remain as is, the business park, and this area is left as agricultural. So therefore, I don't think that Part 1 of KRS's requirements applies in this situation. Part A, Condition A, states again that the existing zoning, you have to then prove that the existing zoning classification is inappropriate and that the proposed zoning classification is appropriate. Page too early. The existing R1A that I pointed out on the northern portion of the site, I would argue, yeah, I do agree that's probably inappropriate. They can't really use it with the amount of space that is there. However, the existing A1 zoning is appropriate. If you look at all of the surrounding parcels south and in the county, they're all agricultural. If you look at the Oxford community, you know, they're all agricultural still. With the information in the comp plan, expansion of our city and expansion of intensity of uses outside of the existing limits is not encouraged. I also don't believe that the B1, well, one, I don't think B1's appropriate, but two, I think that they're going beyond B1. They're going for something that's more like a B2, more like strip commercial development. You know, what they're showing in the comp plan is an idea, but it's still at the intensity of use that they're proposing. It's really not what we would consider the typical neighborhood commercial development. I don't think that they've provided justification for the demand for commercial in that area. You know, that's something that could be studied further during our comp plan. In this area in 2006, they did recommend some expansion north, but it was done with the study of the comprehensive plan and figuring out if and when and how much is appropriate to expand. I jumped around in my points a little bit. And that comp plan process is beginning again this summer. I believe that the B1 is also not appropriate because they're not serving the local residential neighborhood. It's intended to serve the business park and not to meet the regular needs of the surrounding residential areas. What they're proposing on the concept plan is also significantly less than what they could come back with during the preliminary development plan stage. There's also potential for increasing traffic demands, future requests for expansion on this arterial road. There's also, one of the things that they mentioned is that there needs to be commercial zoning in the vicinity so that people from the Lanes Run Business Park have a place to go eat lunch. In addition to not serving the residents, maybe some of the residents go there, but it's primarily serving workers, non-residents. In addition to that, the Lanes Run Business Park has the opportunity to provide restaurants and cafeterias as accessory uses. So for example, the BCTC extension could have a cafeteria if they wanted to. It just has to be considered an accessory use to the primary purpose of each facility. So it is very feasible to provide that commercial restaurant type or retail type service within the business park. And if you look at the land use map and the future small area studies where it called out the North Georgetown market area or whatever they had called it, that study, it's possible to provide those services all there without expanding. Okay. So in the finding that Part 1 and Part A I don't believe that those apply. They have to go next to Part B, which states that there have been major changes of an economic, physical, or social nature within the area, which were not anticipated by the adopted comp plan, and which have substantially altered the basic character of the surrounding area. My first point there would be that the Lanes Run Business Park was anticipated. It's been called out in the 2006 comp plan. The choice was to, provide those services there, but not to expand the city, not to expand the urban service boundary, not to show commercial in that vicinity. It was also considered in other area studies and traffic studies as well. So the Lanes Run Business Park is a well-known thing. It was reviewed and approved in the early 2000s. The other argument is, in addition to being known, they're not really yet substantial. Yes, there's a new entrance there, but it's not built out. Only a few of the parcels have actually been developed. I think that at this time, the requested zone change is premature. It may become appropriate at some point, but I just don't think that we're there yet. And again, our comp plan and future land use map show the business park as is, and they leave agriculture and the city boundaries where they are. At the workshop meeting, you asked me to contact District 7 to talk with them, and Cynthiana Road in this area is not a controlled access road, so they could be able to gain a permit for an entrance off of Cynthiana. From talking with their staff there, the exact proposed location on that concept plan may not work, but in theory they could have something somewhere else. In terms of provision of a traffic light, I was basically told that'll be a long-term project and a bit of a long shot, at least right now. They said that to make a decision like that, they would have to have enough traffic volume and demand for an 8-hour period, it needing the turns and needing a light to provide access for 8 hours of the day. So not just in the peak morning, not just in the peak evening. It would need to be constant throughout the workday in order for them to come in and install a light, either at the entrance of the business park or at Delaplane Road. So the way that I look at that is basically until Lanes Run Business Park is built out, and unless there's a lot of development along the east, kind of southeast side of Cynthiana, I don't see how they're going to reach the demand for a traffic light immediately. So I think by approving this zone change and potential future commercial development, it creates traffic problems. If someone's going to drive out of the business park, make a left turn onto Cynthiana, come out, and then they're going to have to come out Delaplane, make a left onto Cynthiana to get in. It's going to create, if they're serving the workers, they're going to be driving unless enough pedestrian access is provided. But then you've got a pedestrian that has to cross a road without a light with traffic of 55 miles per hour or more. So in terms of the traffic and the accessibility, I think there's a potential issue. And that's why I'm really encouraging that commercial and restaurant uses, cafeteria uses, vending machines can be accommodated within the business park. So people can just not have to go somewhere else. In terms of the conceptual plan, I've mentioned that the scale does not feel appropriate. What they're proposing does fit in within the proposed zone. In terms of the site layout, they were able to meet all the requirements. There's a little bit of the landscape buffer area that would need to be reworked, but that would be done at the time of the development plan proposal. Pedestrian access, I mentioned briefly, but along with this application, since it's along the urban service boundary and the city boundary, they would be required to gain approval to expand the USB in the city limits. So if that's approved, when they develop, they'll have to be developing an urban style site, and so pedestrian access will be an important part of that development, especially if it's going to potentially connect into other areas inside the city. I'm happy to answer any questions, but the staff recommendation is that based on the findings that I've presented tonight and in the staff report, the requested zone change does not satisfy the requirements of KRS, and therefore I'm recommending that you recommend denial of this application.
Megan, do we have any idea, or did the Transportation Department give any insight on what the traffic flow is through there now? Do we have any idea at all what that is?
She didn't really give me any counts, just the words that she used in the general vibe was that it'd be a long way off for any sort of traffic light or signal.
The northeast.
There is a northeast,
Listed
yes.
7,300 vehicles per day on this.
That's now.
Well, I forget which year that traffic study was done. But
Okay.
it was only anticipated, I think, 8,200 by 2035.
And so how many now? Or how many?
About 7,300.
Janet, it's very, very high. When Toyota gets on and off, it's constant
Yeah.
traffic, no, nothing but traffic, but then other times of the day, it's not unusually high.
I've got a question, Megan. Can you go back to the, I don't know which.
Development or the
which
concept
one it
plan?
was. Our little map where it shows the area in itself and how it's
The concept plan?
cut up into different zonings already, please. And where our
This one or
urban
the
service
zoning?
boundary is, well, yeah, that'll do.
I have some attachments here that are, while this one's pretty clear, these are a little bit easier to see.
Yeah, okay, thanks. But I've got a couple of questions here. And maybe you can answer this question, Megan, maybe, I don't know, educate me here, please. So, obviously, a very small parcel, well, not a very small parcel, probably at least a third of this area is in our existing urban service area. That is the dotted line, correct, Megan?
This one is the urban service
Right.
boundary.
Okay. Theoretically, if this was rezoned, what commitment then would the city and our taxpayers have to extend that service to the rest of that development?
To incorporate it as part of the urban service boundary in the city, it would just mean that they're eligible, or they have to connect to city sewer, they have to provide any trash pickup or other services. I don't know the financial cost of what that would mean to the city.
Yeah. All I'm asking is it automatic? If this is
No.
rezoned, is
No,
it?
well, so you would make a recommendation to city council, and they would have to vote to accept the zoning, and then what I'm recommending, or would recommend if you were to change the zoning, or recommend changing the zoning, is to make it contingent upon extension of the urban service boundary in the city limits. So when the city were to get it, they would have to approve all of that together.
It's a little odd too how this parcel ended up with the different zonings, don't you think?
My guess would be that it was done off an aerial and not specifically off of the parcel lines. And so they probably knew, oh gosh, there's that little bit of commercial up at the intersection of Delaplane and Cynthiana. And so maybe by the aerial it was drawn that way. I don't know how else or why else it would cut through a parcel.
Megan, you say that dotted line represents the urban service area. Does that mean sewer actually comes to that dotted line now?
It means that the sewer could be extended to that point.
Where is it now? Back somewhere
It's,
further
I
down?
believe it's across the street somewhere.
across over there.
Somewhere. They'd have to connect to it.
So
But
even
the urban service boundary basically is the extent to which the city would support or encourage the extension
Without any
of the.
further action, they would just do that automatic up to that line.
They, what do you mean?
I mean, they would, if you built a building there and said we want sewer, they would bring it there as long as it was on the south side of that dotted
Well,
line.
they would have to work with GMWSS or whoever to go and connect and bring the line.
Right.
But in theory, if someone outside of, in the county wanted sewer service, it's not supposed to be extended outside of the urban service boundary
Is that what they
because
got?
that encourages sprawl.
Okay.
But it won't necessarily go there just
Right.
because
Right.
it's in. I mean, there are a couple
They have to
places
pay to
that
connect
are in
to it.
town that don't
Yeah.
have it, so, no.
Any further questions for me or?
Any other commissioners have questions for Megan? Thank you, Megan. Applicant?
Thank you, Mr. Chairman. My name is Harold Sims. I represent the applicants, Mary Cox and Doug Smith. I could take a moment to. The tab maps show, I guess, a little bit clearly some of the area we're talking about. Ladies and gentlemen, if, I think the.
You want the page up and page down, it's those two. The zoning? Yeah.
Members of the commission, map number 1 in your package shows, I think what I'm going to trying to be talking about first in this application. The applicants have applied for a zone change on this particular piece of property. It's a 2.173 acre. It's the site that is not the one that's at the intersection of Delaplane and 62, but it's the one that's just south of that, the 2.173 acre site. As you will see in your map, that lot is presently burdened with 3 separate zones, part of which is B1, which is what the adjoining tract has, which is also owned by the applicants, part of which is, and then part of the tract is an R1A zone designation, and part of the tract is an A1 designation. The criteria for a zone change under KRS 100-213 is aptly pointed out by Megan was, is it consistent with the comprehensive plan? I think I think Megan has demonstrated that according to the present comprehensive plan, the use of this particular site is not consistent with the comprehensive plan. I would point out to you that the future land use areas, the future land use in this area for the comprehensive plan does take into consideration some commercial zones. It just calls it commercial, doesn't designate it whether it's neighborhood or highway, but they're basically, it's about 3 5-acre tracts that's just north and east of the Delaplane Road intersection. So the comprehensive plan talks about commercial in this area. My concern with the comprehensive plan's choice of additional commercial property in this area is how does it access the necessary urban services to develop as commercial? If it would have to be annexed, which would be an extension of an illogical extension of the annexation of the city limits, plus the urban service boundary would have to be extended. How would it access sewer services? So if the comprehensive plan is suggesting that the commercial services go north and east of the Delaplane Road site. I have some questions in my mind about how that's supposed to be realized in practicality within any reasonable amount of time, given the existing urban service boundary, existing city boundaries, and the existing land uses in the area. The adjoining site, plus a little bit across the road, is presently B1. So if you take into consideration that the R1A is completely inappropriate for our site because it's way inadequate for any development of a residential site on what you see for this property on R1A. So that part of the site is completely inappropriate. So that brings to that portion of our site that's zoned agricultural, and as a viable piece of agriculture, how much, I mean, it seems illogical to believe that there's a great deal of agricultural use can go on that small amount of property for this lot alone. Megan has made mention that the majority of the property surrounding it is agricultural, but if you look at the lot lines, one of the things you can have in an agricultural zone is 5-acre residential lots. I'll suggest to you that surrounding this site are a lot of 5-acre residential lots. So just because it's agricultural doesn't mean it doesn't have residences on it. They're also in this area, and I think this is a little bit laid out better on map 2, some of the adjoining subdivisions in the immediate area. Admittedly, they're not all built out at this point in time, but they are approved. Lots are on the plan. They've been approved by the planning zoning, and they're proposed for development. So the potential for additional residential uses in the area are appropriate. So we have a small portion of our property, the subject property that we're trying to zone, already has the zone we want to give it. It's a portion of the site is already B1. The adjoining site is B1. And so what it is, I will suggest to you that the existing zoning this lot cut up into 3 separate zones of different natures, one residential, one commercial, one agricultural, is clearly inappropriate, and that what is appropriate or more appropriate is that this entire 2.73 acre tract be given the same zoning as the neighboring tract with the same owners, with the potential for development according to the requirements of the statute for a neighborhood zone. Now, we're required when we file a zone change application to submit a concept plan. My clients clearly do not have an end user at this point. They plan to market the property to people who want to develop it with a neighborhood use concept. We don't know what that will be. It could be a veterinary clinic. It could be it could be an insurance agent. It could be a beauty shop. We don't know. We had to put something on a concept plan. We submitted one. It looked clearly out of scale for the neighborhood, and so when we got to the first committee meeting, we took it back and we scaled it down to where it's more looks like little village type applications, where the buildings are smaller, more to scale, so it didn't look so much like a strip center. When we met the other day, somehow or another the newspaper picks up that we're developing a shopping center. We don't know what we're developing here. We just know that we proposed that this property be given a zone of B1. That's what part of our property already is zoned. That's what the neighboring property is already zoned. And that's what we will have to market it to people. Then when they come in, they'll have to submit a development plan and a use that satisfies that zoning. To negatively impact this application because of what the concept plan looks like, suggests that the concept plan has to be exactly that or something substantially close to it when a development plan is submitted. All the development plan will have to agree with is that it satisfies the uses for a neighborhood commercial zone. If I don't think it would be appropriate for a large scale restaurant, but it may be appropriate for a neighborhood type store, a neighborhood type restaurant where people from the adjoining areas, the surrounding residential zones, the farmers in the area that work the fields and live on the 5-acre tracts and have a farm down the road, they have a place to go. The village of Oxford, just down the road, always used to have a store. It doesn't have one now. This is an opportunity for the use for the people in this area to have a store to go to. Now, will it perhaps serve the Lanes Run Business Park? Clearly, it will, and that's part of the reason why we laid it out the way it is. It doesn't make sense to, if we put this here and people are trying to use it and it's hard for them to use, it will create more conflict in the area than if it was just set up for a single entrance off to the side where nobody can get to it. So we've given you a site plan that has an access to 62, has an access to the Oxford area, so people can get in and out of here in a relatively safe manner. If the people in this area don't have to drive all the way into the Walmart commercial area, that's taking some of the traffic out of the interior parts of these subdivisions and is a safer benefit to those neighborhoods. So it's my suggestion that even though it may collaterally serve the business park, it doesn't mean that it can also serve the neighborhood area. It doesn't make sense, I think, to make it exclusionary, but it can't be set up on a scale that invites those type of things in there. It can't be hotels, it can't be drive-through banks, it can't be, well, maybe a drive-through bank might work if there was a need for it, and it would be certainly serve the service area in a neighborhood zone, but you just can't be inviting the highway commercial type of development in there. And I don't know, Megan puts on a little bit of a crystal ball when she says, well, that's what we're trying to do, because she feels our concept plan looks that way, but we really don't know what the end user is gonna look like. We just know that it's gonna have to meet the criteria of a neighborhood commercial zone. But what is clear and undisputable is that the existing zone on this property is inappropriate. There's no way that 3 competing zones on a 2.173 acre tract is a workable zoning application for this property. The owners of this property are burdened with these uses, and they really can't do anything with it. They can't have a B1 use, they can't have a R1A use, and the agricultural use on it is very minimal. So I think it's appropriate that this body look at the available language under KRS 102.13 to support its finding that this zone change is appropriate by making a finding that the existing land use designation is inappropriate and the proposed land use designation is appropriate. That would make the 2 adjoining tracts of B1 in the neighborhood commercial, and it would support what evidently the comprehensive plan thinks there needs to be some commercial in that sector. So we're just seeking to say, give us another 1.8, 2 acres of our tract that's been kind of cut up. Let's make it all B1 and let us make an effort to try to develop a neighborhood commercial zone in that area. The comprehensive plan talks about what happens when the urban service boundary cuts through a piece of middle of a particular lot, and it clearly allows the comprehensive plan has language that allows for a minor deviation of the urban service boundary when it, in special circumstances, and the example they give is where the urban service boundary cuts through a particular property. I agree that when one of the conditions of this zone change, if it was approved, would be that it would have to be annexed. Here, the annexation would simply have to back up to the back of this property line along with the urban service boundary, so they would enjoy the same line for the two pieces of property, instead of one tract being in the urban service boundary and in the city limits and the other one cut through the middle. I think map 3 shows those urban service boundary and city limits lines, and the wavy yellow line is the urban service boundary line. That it has that configuration because when the comprehensive plan laid it out, it followed the ridge line of the Langfront watershed, and that's why they created the language, because they were following the ridge line. They foresaw that there was a possibility that it would sever, following the ridge lines might sever some lots, and which is exactly what happened here. I think we're simply asking for the minor deviation of the urban service boundary to go back to the end of the subject lot, and the city limits also to go back to that area. They're contiguous with existing there's contiguous with existing city boundary a lot, so we would meet the criteria for annexation. And I think the language in the comprehensive plan clearly justifies the small deviation on the urban service boundary. There is the potential for us to the staff's recommendation for denial because it doesn't look like it's going to be neighborhood commercial, and I think that the time to address that is when the applicant comes in here with a proposed plan that and says, I want to put an Arby's on here. Well, Arby's isn't a neighborhood commercial use, but somebody wants to come in and put a small animal vet clinic in there. I think they have ability to argue to you that does satisfy the definition. The language of the neighborhood commercial zone itself is a little nebulous. It could use some work, and maybe that's another issue for another day. But while it says it serves the surrounding personal service enterprises meeting the needs of the surrounding residential area, and they give some permitted uses: retail sales for neighborhood consumption, consumer services for neighborhood consumption. Neighborhood is in this particular area, when it's out in the county or out on the edge of the county city like this, becomes a wider area. We're in an area where there's subdivisions within close proximity, plus the property is surrounded by 5-acre residential tracts. I think it's appropriate that this area of the town have a small commercial area that they can go to meet their small daily needs. The little things that we run to the neighborhood grocery store in town for, that you run to the dollar store for, the quick in and quick outs, without having to get in your car, travel all the way to the Walmart area. I think the existence of the Langfront Business Park across the street, it makes sense that when we look at this property, we have to realize that some of those people that are going to that school every day may want to stop and get something. They may need notebook paper. They may need highlighters. They may need little things. Is it necessary to send those people all the way into Walmart when they could run across the street? So we develop a use that accommodates others in our neighborhood, but we're set up to satisfy the residential users as well. I think when going down to 213B, where you talk about changes in the area, it's clear that the Langfront Business Park was anticipated when when this was given this zone. But I don't know that the actual use of the 20 acres of that property for a school the size of the BCTCS facility was anticipated. And what that's going to do to the uses in this area remains to be seen. But it's a substantial school. It's going to have a substantial amount of people coming in and out every day, and to require those people to have to go to another area just because, this is set up for residential neighborhood use, and it seems to me to be somewhat short-sighted to say we can't also accommodate somebody across the street. So while I think we can accommodate these other people with a neighborhood type use, we certainly should be allowed the opportunity to develop with the existing zone that the neighboring property has, that the comprehensive plan calls for in the general area, and then you'll have the opportunity to screen the applicants that come through seeking to locate on the site. I think that the findings this board can make is that the existing zone is inappropriate and the proposed zone is appropriate, in support of a finding that a zone change of the 2.173 acre tract to neighborhood commercial should be accepted. Thank you. I'll accept any questions.
Any of the commissioners have any questions for Mr. Sims? Thank you, sir. Is there anyone else here to speak on this application?
I didn't originally sign it, but Jeff, he's going to come up and
You can sign it.
there's no thing to sign up to.
What's your name?
Virginia Teague.
Teague?
Yeah, Teague.
And do you swear or affirm what you're about to say to be the truth, best information you believe?
I certainly do.
Oh, what's your address, please?
I live at 103 Crystal, but I also have property over in that area.
Oh, okay. Go ahead.
I think that from what we've been able to discuss with neighbors in that area, what we get is we really don't want something there. Now, obviously, there's going to be disagreements one way or the other, but I guess all I want to say is if you really want to, if you think it's inappropriate, then you get involved in the new comp plan work that's being done this summer to get it fixed there, rather than to go after a specific circumstance now that's an isolated item. That's all. That's all I have.
Thank you.
Okay.
Anyone else? Commissioners, any questions from anyone?
Charlie, can you give us any insight on this?
Well, clearly, a 2 acre tract is not supposed to have 3 different zones in it. So I think clearly the second statutory requirement is met, that the current is inappropriate. The question for you would be whether or not the proposed zone classification is appropriate. It clearly moves in its favor to a degree because it's adjacent to B1. I can't imagine R1 anything being appropriate for that little squiggle. And I'm not sure you can do a whole lot of farming on whatever that is, an acre and a quarter or something. So it's some of these questions I think are real easy, and then of course some are not. Part of it apparently, I guess that's what this means, part of it's already in the city limits.
Yes.
But as we mentioned earlier, there's no guarantee whatsoever that the city, in fact, it's highly unlikely, I would think the city's going to extend sewers out there for a small tract. There are places where sewers have not yet been extended, so I mean that's not really likely. Doesn't mean that there aren't other ways of handling that need without sewers. So again, I think, and another thing is we've always had B1 out in the county even that was never annexed. So, I mean, that's not necessarily, in fact, once upon a time, we had them probably every couple, 3 miles throughout the county. We've not been doing that of late because people do travel to town. Everybody travels anymore, it seems. I mean, they're just a number, there are just a number of issues. But I do think the first one's really simple. Nothing this size ought to have 3 zones in it. Now, but what is more appropriate? Is that what's being proposed, or is that something else?
Charlie, is it, they definitely would not want to rezone it to a lesser use with it. If you have R1 and B1 and part of it, you would not want to make that entire tract A1. But it's in the urban service boundary.
I mean, it's part of it's in the urban service boundary, so it really doesn't make any sense to plan it A1. It really can't be used for residential, so I mean, that doesn't make any sense. I mean, I'm not so sure that the only thing left isn't a B zone. And when it's right next to one that's already B1, I mean, that at least calls out for some consideration. And I think you need to look at the plan map and see. I didn't quite get from the discussions where the plan actually calls for B1, or I'm sorry, commercial. It doesn't call for B1 or B2, but commercial. But this is in fact adjacent to some. So whether or not that's precisely where the plan is, or that's clearly not where the plan calls for it, I don't have that in front of me, so I'm not real sure about that. But it seems like we need to somehow be aware and try to address the need that it's just absurd to have a piece of property that's got 3 zones in it. Because I don't know how you deal with that. That's in effect saying it can't be used really for anything, and that doesn't really make a whole lot of sense.
My question would probably be for Megan. This concept plan, the way it's shown with the different villages or the different sections, this is strictly a concept plan. It's not proposed for, they're not proposing to build this at all. This is just something they had to dream up.
Right.
Would you feel any differently about it if there was, I mean, you just leave this as a blank piece of paper and that was a B1? And when it comes up for, if somebody does come up with a plan for it,
Potentially, but to me, the question, and Charlie kind of hit at it, is has there been enough support or evidence to show that the B1 is appropriate? And I don't know that question has been answered yet. Yes, it is weird to have the different zonings all on the property. Could potentially something like that work? Maybe, but I would hesitate to grant zoning before we know for sure that it can work. I understand like the contradiction between saying, I guess what I'm trying to say is before you grant a zone change request, I would want to feel confident that whatever level of development is provided there is going to be appropriate. And while that concept plan could change, certainly there's something that could be worked out that could be appropriate, but we don't really know what that is. And I don't know that we have the capacity to require it to be exactly what we want it to be. Once you give it the B1 zone, if they satisfy all our requirements, it's really hard to come back and say no. And so that's why I think waiting until the comp plan and looking at it this summer and understanding what type of commercial, what type of markets do we have for growth, especially at the city boundary lines, what type of growth is appropriate, what type of zoning do we need more of? Is there enough of a neighborhood there? Is there community want and need expressed that area should grow? I think that's why waiting for the comp plan process is appropriate in this case, because I personally don't see that there's enough to say that B1 is appropriate here right now.
You kind of don't want to approve a pig in a poke thing is kind of what you're saying here, because you don't know what's going in there. Well, I have a question. These, on this map 1 here, which is very well done, I might say. It looks like you gave a 2-year-old a crayon and said start coloring. It doesn't look like there's any logic at all to where these zones of the D1 and the
I think Harold
R1A.
had a good point that part of that probably came from the Lands Run Basin, from something from an aerial map that showed where that basin, where things would pull.
Did this body decide
That could
or
maybe-
did somebody?
I would need to do further research to figure
It
out
makes sense to
where
me.
that came from.
Actually, and my memory may be terribly faulty, but I think that's exactly what happened. They went down the topo map, took the high points of that basin, and they added the basin. They didn't say, well, let's add the basin, take away property lines. They added the basin. So you could have literally had a property that was 2 feet outside the basin, and that'd be excluded. And that's where the adjustments and things are made.
Who is
No.
they? You said they
Well, the
did.
planning commission would have done it, and then the legislative bodies would have adopted it.
Okay, so it
But
went
the
through.
expansion of the urban services boundary was to include the Lanes Run Basin, and that was done quite a few years ago.
I would also suggest that possibly some of that comes from where the properties were before 62 was put through there.
Oh.
You went back to the deeds before that came through, you might find that was actually a continuous piece.
Oh, of course, because there's been quite a bit of road work done since then, so of course that would have changed even the
Yeah.
addition
That's-
of the basins themselves.
That's my theory for why the
But that would've been
R1A
started.
is there, because there probably was residential at some point, and then at some point the road was widened and, transportation department came, took land, and then that's why you get a strip that's kind of left over.
The road wasn't widened, that was a new road. 62 used to be up
Yeah.
with Oxford.
Yeah, over behind it.
Oxford Village Lane.
Yeah, behind the properties now.
Thank you, Megan. Yes, Mr. Sims?
I have a black and white version of the future land use area map that shows what Charlie asked about, where the proposed new commercial areas are. I wish I had the color version of it, but it's for here. Basically, these tracks in here are proposed uses, and this is the circled area is where we are, and that's where the squared area is the proposed future commercial use that I was talking about, just north of the Delta Plain Road area, and outside of the urban service boundary, outside of the annexation. I would just comment on the sewer issue. It's the applicant's intent that this property would be sewered, and they're prepared to develop it or encourage the developers to access the sewer that will be on site at the in the Lanes Run Business Park through use of boring under 62 and connecting and obtaining easements to connect over there. Now I think that was probably I think that was part of the conditions that Megan had attached to it if you approve it, and it's the applicant's intent to move in that direction and acquire the necessary easements.
As we're passing this through, any other commissioners have any other questions of anyone? As soon as they get a chance to look at this, we'll proceed. please?
Can I ask a question of Megan?
Sure.
Is there an automatic assumption that that proposed fewer use beyond, on the north side, will automatically be put into the new comp plan?
So for Mary's sake, I'm gonna repeat the question. The question was, if this zone change is approved, is it kind of assumed or automatic assumption that that would be reflected on the future land use map and in the comp plan?
I'm sorry, I wasn't clear. The drawing that they're passing around of proposed possible future commercial development beyond what is currently.
I think they're passing around an existing map. I haven't seen what they're passing around, but that's a.
You said that was.
It's the GIS version of the future land uses in that area.
So that's an existing future land use, or it's a current map that has been created already in 2006, but it shows what is called future land use.
Is there an automatic assumption that that future land use will become part of the comp plan work that's being done this summer?
I'm gonna try and answer that question, but maybe not exactly what you asked. The future land use map designates areas for what the community has decided on a map, what types of use might be appropriate somewhere. And so when zone changes come for review, usually when an application proposes a use that matches with that future land use map, that's when we have a much easier time of recommending, hey, this has been considered, this was what someone wanted, that the community voiced support for, that there was some sort of reason to propose this. So one, kind of when we redo the comp plan, when we update it, we'll look at everything that's out there and we'll try and figure out, is that still appropriate? Does there need to be more or less of anything?
But it's not an automatic assumption.
It's not
built in.
It's not automatic.
Okay, we have any more questions or discussion? If not, I'll ask for a motion.
Do you have to close the public hearing?
At this time, the public hearing is closed. Thank you, Ms. Holland. I'll ask for a motion.
I'd like to make a motion to err on the side of caution based on the staff's recommendation to deny this application at this time.
I would second that motion.
We've got a motion and a second. Okay. We're going to have a roll call on this. The motion was by Mr. Moran, second by Mr. Wiseman. All right. A yes is in agreement with that motion. A no is in disagreement with that motion. Okay. Ms. Holland?
No.
Mr. Caldwell?
No.
Mr. Smith?
No.
Mrs. Mizell?
No.
Mr. Moran?
Yes.
Mr. Solsky?
No.
Mr. Wiseman?
Yes.
We have 2 yeses and 5 noes. The noes carry.
Does that open us up for another motion?
I believe it does.
Mr. Chairman, I think reading what we have here in section 100.213, that the existing zoning classification given to property is inappropriate. I think we can say that it's inappropriate. It has 3 different zones on a 2-acre tract. As far as part B, that there have been major changes of an economic, physical, or social nature.
Excuse me, you don't need to find A and B.
Just
If you,
one.
if you find A, it's simply that the current is inappropriate and what is proposed is appropriate. You don't have to go then to B. If A doesn't work, then you gotta go to B and see if that applies.
Right. Well, I would argue that maybe we do need to tighten our standards for B1, so that we can say more confidently what we want to go in there. If our standards are not what they need to be, we need to change those. But I think this track needs to have one zoning, not three. And I don't think it would be fair to lessen it to A1, and it wouldn't work for R1. So I think the only thing that leaves is B1. And I would argue that's appropriate. I'd make the motion that we accept this application.
I'll second that motion.
All right, we've got a motion by Mr. Smith to accept. We have a second by Mr. Sulsky. Okay, yes is in agreement with that motion. No, obviously, is in disagreement. Mr. Wiseman.
I'm a little confused. What did we just vote against in the other action, recent action? How does this compare?
There was, Mr. Moran made a motion, correct me if I'm mistaken.
That was to deny,
To deny.
based on
Yeah.
staff recommendation.
Yeah.
So we didn't deny it. Now we have to go back and actually approve it. Is that what?
Well, not necessarily, but that's
No.
the motion on the
That's the
floor.
motion.
No,
That's
we
the
can-
motion.
yeah.
Approve it.
Motion now is to approve, not to deny.
Yeah.
Yeah, and that's based on
So
section 1A, which says the current classification
if you're against
It's
it, no.
inappropriate.
is inappropriate and the proposed classification is appropriate.
And you want, and a yes on this would be to vote to
That's-
change it to B1, change all the south track to B1.
You're exactly
Yes.
right. Yes, sir. That's the motion on the floor.
Okay. And you're asking me to vote, and I'll vote yes.
Okay. Mr. Smith.
Yes.
Mrs. Holland.
Yes.
Mrs. Mizell.
Yes.
Mr. Caldwell. Yes. Mr. Moran.
No.
Mr. Sulsky.
Yes.
Okay, we have 2, 4, 6 yes and 1 no. The yes carried.
Hey, excuse me, Mr. Chairman.
Mr. Chairman, you can.
Oh, well, no, before that, Mr. Chairman, Mr. Current Chairman or Vice Chairman.
Yes, sir.
It just dawned on me, that motion did not incorporate the staff recommendations in the event of approval. And I wanted to make sure that was specifically said, either yay or nay. So if that was intended and we just didn't mention that, then I would like Mr. Smith to make a second, well, not necessarily, but someone to make a second motion to accept the recommendation and apply those conditions to the approval.
I would make that motion.
Those are on the page 6 of the staff report.
Yes, I'm sorry.
And those are basically the standard conditions. But you'll recall it said recommended denials of the top, but however, should the commission find in favor of it, then they recommend those 7 conditions.
You need a second or anything?
Yes, we need a second to vote on that too. Yes. And since that's still a zone change connection, do that roll call again, please.
Do we have to-
Okay, everyone understand what's going on?
Conditions approved.
We are now gonna do another roll call, because you are, we're adding, now that it's, looks like it's gonna be approved, that we are adding the recommendations by staff. Mr. Wiseman.
Yes.
Mr. Sulsky.
Yes.
Mr. Moran.
Yes.
Did you change your vote?
Oh,
Yes.
no, I'm sorry.
Oh, okay. I was not, I just.
Yeah, this is
wanted to make
different. Yeah, this is a different vote. This is simply to add the
sure. To add the recommendations to
Yeah,
it?
yeah, this
Staff
doesn't,
recommendations.
Okay.
yeah, this isn't the original. This is just to add those 7 additional conditions that staff recommended in the event of approval.
Yes. Sorry to confuse you. Mrs. Holland?
Yes.
Mr. Caldwell? Yes. Mr. Smith?
Yes.
Ms. Mazzell?
Yes.
Oh, yes.
Five minutes.
Well, he's been on break for 30. What's he need a break for? We're gonna take a 5-minute break right now, and we'll resume very shortly.
Thank you, Ms. Janet.
his concern had been the access on one of the lots. And by showing him what was proposed as a condition of the staff report, that was enough to satisfy him. So there's no one, as far as I know, if someone's here to speak up against the application, please
Well, that's
speak
right,
up.
because that's the
But-
guy that made us have the hearing in the first place.
Yeah, but I don't know if it can, I don't know if it can still go consent or not, or if I need to run through things, or.
If Mike was the only one and he's not, and the commission doesn't, then
Yeah,
I think the
commission
motion.
doesn't have any
Yeah, the motion would be perfectly
questions.
fine now, just like it would have been then.
You got questions,
But
Frank?
for some.
Oh. I mean, do we need to take a vote on whether to approve it?
Oh, no, seriously, if no one else has any question, I think you could ask for a vote to make it consent. If no one else has any questions or concerns about it.
Do we need a motion on it then, Charlie?
Yeah.
A motion for consent? Do we have a motion for consent?
I'd like to make a motion for the Everly property to go to consent agenda.
A motion by Mr. Shirley, a second by Ms. Holland. All those in favor?
Aye.
Those opposed? The motion approved. So moving right along, we have the Holger Snyder Building.
We're just gonna jump ahead in the slides. This one also went consent. This application is the Hutker Schneider Building. It's application PDP 2015-14. It's a preliminary development plan for a 19,600 square foot commercial building located on 1.74 acres, just northeast of the intersection of Lyle Road and Lexington Road. The property is zoned B2, surrounding zoning. Go to this page. I think I put a zone, I didn't put a zone. The surrounding zoning in this area is industrial and agricultural. A little bit farther east is the mobile home park. For this site, I've got the development plan up on the screen. The proposed building is located on the southern portion of the site with the parking just north of it. 30 spaces are provided with this development plan. That's calculated using 1 space per 1.5 employees at their largest shift, plus 1 space per 150 square feet of retail floor area. Or, sorry, 30 is required and 39 spaces are provided. If I make any stumbles, I apologize. This is one of Joe's reports and I'm reading through it. They are requesting a variance with this application. The standard setback, they need to come in and reduce the front setback by 20 feet in the front. Is that correct?
Reduce it to 30 feet.
Reduce it to 30 feet, from 50 feet to 30 feet, it's a 20-foot variance. Here in the front for this kind of bump out, and I believe that's where the retail space is proposed in this site. That's correct, okay. One of the things to note in the B2 zone district, the retail portion of this site is a permitted use. The warehousing and manufacturing production of the t-shirts, that's actually something that is permitted as a conditional use. So in conjunction with this application, the applicant has also filed with the Board of Adjustment to apply for a conditional use permit for that use. So that would be incorporated in the conditions that they would be required to obtain that conditional use permit to operate that use and build this development plan. Some of the key issues and comments that Joe brought up at workshop and then also through his staff report is addressing the US 25 small area plan. That study was originally done in 2001 and updated in 2013. Part of that study recommends a landscape buffer along US 25, a 25-foot landscape buffer. And what what he and the applicant are kind of working out is using some of the existing trees that were planted with the widening project, incorporating those into some of the calculations, and then staggering some of the extra trees. I think they were talking about potentially adding some more in some of the unused areas. One of the other notes from the small area study was kind of the general look and feel of some of the buildings. And so while we don't have official adopted standards, he's recommending going away as much as possible from a big box type use. So after I kind of review some of the other comments, I have some images, renderings of the proposed structure for you to review. The maximum building area for B2 is 50%, and this site with the proposed facility of 19,000 square feet is only 25% of the buildable area that would be permitted. In terms of parking, they have exceeded the required number of parking. They have a pedestrian access sidewalk around the building. That's right here. In terms of landscaping and screening, so the perimeter viewway requirement is a 3-foot hedge and 1 tree every 40 feet of frontage. They're only showing the hedge and not all of the trees. So when I mentioned before that some of the trees might need to be relocated, I believe that's what was kind of worked out at workshop, was that some of those extra trees could be placed on the site, but not necessarily right along the perimeter. There's some other comments about just making sure that all of the required landscaping is met on site, but that it can be worked out and included in the planning schedule on the final development plan. There are some environmental concerns on the site. I'm just going to read a little bit, but the subject property was proposed to be served by an existing private package treatment plant that serves the Spindletop Mobile Home Park and the other mobile home parks in the area. The owner has an agreement on this treatment plant to tie into that when available. And I'm going to kind of summarize, but Jean Thomas from the Health Department is here if you want more specific comments. So what they're showing on the site is a kind of storage tanks on the site that will have to be kind of pumped out and cleaned, I think, on a weekly basis. And so that's a proposed temporary use, because right now there's some ownership or bankruptcy kind of connection. They can't connect to the package treatment plant at this point, and so what they're proposing is a temporary solution on site. And one of the conditions that Joe is recommending, and it's not in your staff report, but it's listed on the new ones that I gave to Charlie, would be that because the goal is for them to eventually connect, but we don't know for sure if and when that can happen, that there would be kind of a 2-year limit, and that they'd have to reserve adjoint land in the adjoining property on this, I believe he's mentioning on this side, to accommodate leach fields if they aren't able to connect to the sewer. And so they would still need to provide a subdivision plat and putting that language into the plat. Is that a decent summary, or do you want to expand on that?
I'll expand on that later.
Okay. Joe's also recommending that because the subject property is near the boundary of the Royal Springs Aquifer Recharge Area, it's recommended that it go for review to the Royal Springs Wellhead Protection Committee to analyze affluent and what's going on in the area before the conditional use permit hearing by the Board of Adjustment. No signage has been proposed. They will, based on the zone change that was granted, some of the conditions that they submitted were that they would meet the B1 neighborhood commercial sign standards, even though they have the B2 zone. So they'll have to use a monument sign. they'll have to meet all the stormwater and lighting recommendations. So I'm gonna flip through the building elevations that have been submitted. In general, I believe that Joe was speaking with the applicant, and they're trying to figure out if and how much more they want to do in terms of any additional architectural ornamentation or cupolas or windows or, exactly what they want this to look like. But I'll let the applicant talk a little bit more about the actual building design and the materials that they're proposing. And then Jean for any questions. And I've included the recommendations as you have them in your staff report. Just they're missing what I've called condition number 15, and maybe Charlie, I didn't type it out, but maybe you could read that for everyone.
The applicant shall provide an agreement with the adjoining property owner to reserve the right to use land area required by Environmental Health Department for reserved septic system drain field in the event that connection cannot be made to public sewer or package treatment plant within 2-year period.
Thank you. Do you have any questions for me?
So if they don't own that land north of them, they would have to lease it for the drain field or something?
Yeah, just to reserve space for the drain field.
They don't own
If-
that land?
I believe they own the bit that's connected to them, but just making sure, if they subdivide and want to sell off, they have to have some sort of agreement with any sort of new owner that they would be able to use that property for the existing site. If that makes
Is that
sense.
kind of unusual?
No, I mean, it's similar to the agreement they have to use the package treatment plant with the
Okay.
mobile home park. It's just making sure that it gets incorporated.
Any more questions for Megan? Thanks, Megan. Is the applicant?
I'm Blaine Adamson. I'm the owner of Hands On Originals. Thank you for letting me talk. I just want to introduce myself real quick. Maybe give you a brief, really quick, of why we're coming to Georgetown. One, the state approached us a little over a year ago. They're widening New Circle Road, and they're acquiring our building through condemnation. And originally, we had about a year and a half from what they originally told us, but that date with the state keeps changing. So time is kind of the essence to try to find another location. I live in Scott County. I do life here, and it was 6 years ago that I met with Bruce Smith to move our business to Scott County. And so this was a perfect opportunity. Most of our employees live on the west side of Kentucky. They live in Lawrenceburg, Shelbyville, and Frankfort. So we want to try to stay on this side, and thus we're here. So, we're a screen print embroidery company, and so we look forward to coming out to Scott County. A couple things I would like to mention, and he may make me not talk, but one of the things on requiring that variance, I believe it was stated, was it did look like a metal box, and that's not something that I wanted. I wanted to make sure it had a little dimension to it, and one of the things that Joe had mentioned after that was he wanted us to add something to it, so we put that deck on the front of the building. If you see, that was an add-on, I believe, since he asked us to do that. So we felt like that gave it a little bit more of a personality, and so we're definitely with you guys on that issue. So, thank you.
Good evening. My name is Glenn Weary. I'm the builder. I'm the construction center manager for Morton Buildings Incorporated out of Frankfurt, and I've been working with Blaine on this project since last November. And so we're anxious to hopefully get started. If you have any questions for me of type of construction, how we build, what we use, material-wise, et cetera, feel free to ask.
I had one question. I was thinking that there was a mention of a cupola or something on the roof. Is that still in the plans?
Yes, sir. Basically, we'll be adding, Megan, if you could go to the next slide, please. Basically, the entire structure from end wall to end wall is 190 feet. It's a 100-foot wide building. On that size of structure, typically you'd put 5 4.5 by 4.5 foot wide cupolas on top of that to dress it up, make it look a little more equestrian-esque to kind of fit into the area. That's basically our next step in the design process to make it fit into the
I
area.
think that would break it up real well.
Yeah, that's the goal. We wouldn't use just one. We'd probably do about 5 on that length of building. I think that would break up the roof line to make it a little more dressier, which is the goal. Other questions?
So all the conditions of approval, you guys are good with all those, the 15 conditions? You know, we had 14 plus the 15 one that Charlie just read. Anyone have any more questions for the applicant? Is there anyone else to speak on this, Charlie? Thanks, guys.
No, that's everybody. Well, there's people involved with this project, so, but otherwise, there's nobody else on the sign-in sheet.
Anyone speak against it?
I'd like to hear from Mr. Thomas.
Yeah, I would too. I got a couple questions for Mr. Thomas.
Mr. Perkins, I have not signed in.
I was gonna say, I didn't think I'd seen your thing.
My name is Gene Thomas. I work for the Scott County Health Department.
And you have a right hand.
And I have a right hand.
And you swear or affirm what you're about to say to be the truth, the best of your information, please.
I do. To start off with, I'll give you all a little bit of history about the sewer and this and that. Package treatment plant's been out there for many years, I think the late 60s, and so forth. Currently, Mr. Dwyer's mobile home park's tied onto it, the Ponderosa mobile home park and so forth. And we've been working since 2006 to try to get municipal sewer out to the county line to pick up the mobile home park, several other people. It's a $3 million project. We've got $1 million that both City Council and the Fiscal Court here granted use from the reservoir for that project. We have been slow in working toward that due to the owner of the mobile home park not cooperating with us, but that's another story. So basically our options for this particular property is we don't really want to install a leach field in this particular area at this time because, as we all know, we want to protect that basin of the aquifer in that area or the watershed. So also we want them to hook onto the package treatment plant, but due to some litigation and things and so forth at this particular point in time, we are not able to do so. However, I feel very confident after talking with an attorney today that represents the bank that's the receivership for the mobile home park this time, that it won't be a problem for this facility to tie on to the package treatment plant. One thing I will tell you, I have done a little research. Their water usage per day is about 555 gallons a day, so it's not a really large flow. Our on-site sewage code requires that a holding tank have a 7-day capacity, be large enough to hold a 7-day capacity discharge. So I sent an email to Mr. Hayes with Thoroughbred, and I'll just kind of read a little bit of what I wrote him and what I want on the plat. I basically said, please put this on the plat regarding this facility. I hereby certify that the sewage treatment system installed or proposed for installation on this property fully meets the Kentucky Cabinet for Human Resources specifications and requirements. The holding tank is approved for a maximum of 2 years from the date of installation, at which time the facility will tap on to sewer or install a leach field. So I was going to have them put that on the property. Other requirements that we would require would be they would need to have a contract with a certified septic tank pumper. They would need a minimum of a 3,885 gallon holding tank, and they would also need a high water alarm will need to be installed on the holding tank, so when it reaches 85% capacity, they call our septic tank pumper. He pumps it out. He's required by law to write down the date, how many gallons he pumped out, and where he discharged those gallons to. So at any time, we can look at those records and require that, hey, I want to see what you've been pumping, where you've been taking it, and so forth. So yes, we would like them to hook up the package treatment plant. But at this point in time, that cannot happen. So we were gonna try to give them another option that would still meet the code, still protect that watershed, and hopefully in the near future will allow them to hook up to the package treatment plant. If that should not happen, they could designate another area for leach field in the future should that not happen. And ultimately down the road in long-term use, hopefully we'll have municipal sewer and hook everyone in that area up to sewers at that time.
That was gonna be one of my questions, is the sewer line y'all are proposing to go out there gonna be big enough to carry this? I mean, is this property here included in that
Originally, I think
plan?
going back to 2006 when we started this process, the intention of the municipal sewer was to serve that area with the existing customers or facilities that were in that area at the time. It wasn't necessarily designed for future development, because I think in 2013 there is a small area, and this is one of them, for the US 25 land use plan. So there's not a whole lot of more commercial development in that area.
I guess my second question would be the package treatment plant. I think you mentioned you've been dealing with them since 2006. They've been having issues with it. So the addition of this property joining onto that package treatment plant's not an issue at all?
Yeah, it should not affect the capacity or their at capacity at this point in time, and so forth. So I don't really, now if somebody proposed a facility that was gonna use 10,000 gallons a day or 20,000 gallons a day, then you could very easily maybe go over capacity on the package treatment plant, but I don't see that problem at this time.
Does anyone else have any questions?
Answered my questions.
You gave me what I want to hear.
Thank you.
In my mind, I think this is probably this is a fairly low usage of water. It's probably the best case, one of the better case scenarios for that property.
For that treatment plant, I agree with you. Is there any more questions, any more comments? If not, we'll need a motion to approve the
I'll
project.
make a motion to approve.
To approve, we have a motion by Mr. Solsky.
With 15 conditions. 15
Yes,
conditions.
according to staff recommendations. Thank you.
And a second by Mr. Caldwell. All those in favor?
Aye.
Those opposed? Motion's approved. Thank you, guys.
Compliments of Kentucky. Which one?
You got anything else, Megan, or Brent, or an update or anything? Anything else? I guess upon that, meeting's adjourned. Thanks, everybody.
Public hearing before you ask for